We'll hear from the appellant.
Good morning, Your Honors.
Good morning.
My name is Laurie Hall. I am a member of the Memphis Bar, and I represent the appellant Tyler Russell. I would like to reserve 5 minutes for rebuttal, please.
All right.
This appeal arises from a divorce action involving a very short-term marriage. The total time that these parties were married was 3 years, and the amount of time that the parties cohabitated as husband and wife was just over 2 years when the trial began. Tyler Russell and Hannah Melton Russell were 28. Hannah was 28 and Tyler was 30 at the time that this case went to trial. Both parties were living with their parents. The wife was a registered nurse who had reduced the number of hours that she worked. Previously during the marriage, she had earned more than the husband. The husband was a clinical research associate at St. Jude. This case was contentious from the start. There were issues involving placing the house on the market to be sold, the marital residence. There were issues pertaining to my client, the husband, retrieving his personal property, including his car, from the marital residence. There were numerous motions filed, including a motion to amend the complaint for divorce, to add my client's parents as parties, which was never heard. There was a motion pending light filed by the wife that was never heard. There were other motions to dismiss filed by the wife that were never heard. My client did, fairly early on, file a petition for criminal contempt, which he later amended, alleging that the wife had given away or sold various items of personal property that were both marital and separate. The trial itself took 5 days to try, and I would submit that if Your Honors read the trial transcript, 3 days of that 5-day trial were spent by the wife's counsel questioning the wife about the grounds for divorce in this case. There was a lot of duplicative testimony which the trial court allowed. Before I get into the issues that I'm appealing, I would like to address the standard of review. In my brief, I know opposing counsel pointed out that I did not specifically state the abuse of discretion standard, and I do want to be clear that we do agree that an abuse of discretion standard would apply both to the appealed issues of attorney fees and as to alimony. An abuse of discretion occurs when the trial court applies an incorrect legal standard, reaches an illogical conclusion if there's an erroneous assessment of evidence, or uses reasoning that causes injustice. As to the issue of attorney fees, we submit that this was not a case where the trial court should have awarded attorney fees. This court awarded, the trial court awarded wife $75,000 in attorney fees.
Did I see that, was there, and I've read the briefs, but I haven't read the entire record in this matter. Was there ever a hearing regarding the attorney's fees or any specific findings by the court as to specific fees other than just an amount?
There was not, which is hugely problematic. What happened was that the wife's counsel actually did not even submit the affidavit of attorney fees, the final affidavit of attorney fees, until the trial was over. It was accepted as a late filed exhibit. And when that affidavit was filed, it had no billing records attached. So there is nothing in the record, no exhibit, no testimony as to the type of retainer agreement or employment contract that the wife signed, the hourly rates. There's nothing regarding any billing entries, and that was never submitted during the wife's proof. The wife's total attorney fees in this case were over $200,000. By comparison, my fees were over $66,000, which I still thought was excessively high for this type of case. An award of attorney fees is alimony in solito, and so, of course, the trial court should have gone through the factors enumerated when a court makes an award of alimony at 36-5-121I.
Ms. Hall, let me ask you a question about the late filed exhibit there. Was there any motion or any other type of objection filed with the court or any subsequent hearings as to that late filed attorney bill?
There was not. When the court allowed there to be a late filed exhibit, I believed that the bills would have been attached to the affidavit. That's what I had done, but that's not what happened. And so what occurred in this case is the court received this late filed exhibit and then just issued a written ruling after the fact. So there was no subsequent hearing, no opportunity for a subsequent hearing after the trial took place.
All right.
An award of attorney fees is appropriate when a party lacks sufficient funds to pay their fees or other assets would be depleted to pay fees. At the time of the trial, the wife testified that her attorney fees had been paid in full by her parents. Wife claimed at trial that she owed her parents back for those fees, but did not list any debt owed to her parents on either her 14C or her 14D memorandum. Wife presented no proof related to the affidavit of attorney fees, as I've already touched on, and there were no bills for the court to review. In ordering the fees, the trial court did not apply the correct legal standards. The court did not go through the factors enumerated at 36.5.121I. The court made a very passing cursory reference to those factors, but did not even incorporate by reference in her findings of fact and conclusions of law those findings that she had made separately when she awarded alimony to the wife. The court also did not go through the factors found at 36.5.121H. And even if I would submit if the court had gone through those factors, it would not have supported an award of fees to wife.
Let me ask you a question again, Ms. Hall. You said that the court in its final decree of divorce did not incorporate its findings of fact?
No, Your Honor, the court in its findings of fact and conclusions of law under this section pertaining to the award of attorney fees did not incorporate its earlier findings under the section pertaining to alimony.
Oh, all right.
So
I'm
the
sorry.
court did, in its findings of fact and conclusions of law, the court did go through in making its award of alimony to the wife the individual subsections under 36.5.121I. But the court then, in the section pertaining to the attorney fee award, simply made a passing reference to those factors without incorporating those again by reference into that section.
You're talking about on page 33, the very last thing.
The discussion of the attorney fees begins on page 33. I believe where the wife made the reference was on page 35. But there is no, she did not incorporate by reference her specified findings that she made earlier in her findings of fact and conclusions of law.
Okay, and so I noted that when I reviewed the order on page 20, she stated under the section 6 for alimony, the court incorporates by reference the findings of fact as to grounds for divorce as findings of fact for alimony as if repeated. So you're saying that that doesn't then apply to the attorney's fee award as alimony and solito?
I believe that the court should have separately stated under the attorney fee section that she was incorporating by reference her findings that began on page 21 and continue for some pages to page.
Yeah, I don't want to take up your time with all that. I knew that there was a reference under the alimony section, but your argument is that she should have said it again under the attorney fee section.
And incorporated it by reference, yes.
Okay.
And that she did not do so. And then the court also did not do an analysis under Tennessee Supreme Court Rule 8, Section 1.5. According to Ellis, the court is required to make findings regarding each factor. The court, again, just made a passing reference without going through those enumerated factors. And I would submit that the court would not even be able to do that because the court didn't have the bills, didn't have the employment contract. And so it would be impossible for her to do so. So for those reasons, we're asking that the court, this court, vacate that award. We're not asking for the court to remand it. We would just like the court to reverse it and find that the fees were not warranted. And then quickly, as to alimony, I know that this was a very modest alimony award. It was just $1,000 per month for 12 months. But I would submit that if this court looks at the factors that the court weighed that favored alimony, there were only 3, one of which was fault. The court made erroneous findings as to the fault. The court spent 3 pages on fault, and there was only a paragraph for each of the other factors when the court went through those factors. The court erroneously found that the marriage was not consummated on the honeymoon. That's not true. The wife herself stated that it wasn't the first night, but that the parties did have sexual relations. That's an erroneous finding that the court seemed to heavily weigh for fault. And so in considering the totality of the factors, an award of alimony was not appropriate for this very short-term marriage. Thank you.
May it please the court, my name is Jacob Vanzen, and together with my law partner Donald Caparella, I represent the appellee in this case, Ms. Hannah Russell, née Melton. This is a straightforward alimony case where the appellant husband is trying to make the trial court's memorandum opinion into something that it's not. I want to begin by correcting the record real quick as to incorporation of certain factors regarding alimony into the alimony and solido award at the end. On page 35 of the court's final order, which is in the record, volume 6, page 854, the court says, based upon the foregoing and the analysis of the factors set forth in the alimony ruling herein, the criteria set forth in Tennessee Code annotated 36-4-121, and the factors set forth in Rule 1.5 of the Tennessee Rules of Professional Conduct, the court orders the husband to pay wife the sum of $75,000 in her attorney's fees. It's in the very last paragraph right before that it is therefore ordered. And my contention is that when the court says, based upon the foregoing and the analysis of the factors set forth in the alimony ruling herein, she is referencing specifically the alimony factors that she went through earlier in her very same order. I also want to move then after that to addressing something which came up during my opponent's initial argument regarding the procedure that was employed in the affidavit regarding the affidavit of attorney's fees. So on the last day of trial, my client's trial counsel neglected to bring the affidavit of attorney's fees with her. And the court said that it could be filed as a late filed exhibit. And so then it was actually filed that same day. So I don't know if somebody else in trial counsel's office filed it or trial counsel went off and filed it, but it was filed in the court record that same day. And so the court then, and it appears in the record in this case, the court then had access to that attorney fee affidavit. And opposing counsel, and really the party, the husband in this case, never requested a hearing on the attorney's fees, even after the affidavit was submitted. And so the rules of appellate procedure state that a party waives an error, to the extent there was any error, a party waives an error by either failing to properly object to the error, allowing the error to happen, or failing to take reasonable steps to correct the error. And here the obvious reasonable step was to ask the court for a hearing on the issue of attorney's fees. And I will point out that there was quite a gap between the last day of trial and the court actually issuing its findings of fact and conclusions of law, so long of a gap that the parties filed a joint motion to basically ascertain the status of the ruling. And yet, despite the parties filing this joint motion to ascertain the status of the ruling, the husband never came forth and said, we object to these attorney's fees and this affidavit that was late filed, which again, the court permitted the opposing counsel to do. The court permitted my trial counsel to do. And I also want to bring the court's attention to a specific citation in the record. So this is in the transcript of March 8th, 2024, which I believe is the last day of trial. It's at page 100 of the transcript for that day, and that's record volume 14. And it begins with Ms. Irvine, who was trial counsel for my client. And I'm just going to read it because it's really relevant on this point. Ms. Irvine, then I believe our affidavit of attorney's fees has been filed now, but I will, with the court's permission, submit that as a late filed exhibit. The court, okay. Ms. Hall, I don't have a copy of that. Ms. Irvine, I will get one for you. Ms. Hall, can I get it right now? Ms. Irvine, I don't have it right now. The court, but is there any? Ms. Irvine, I was notified that it is being taken care of now. The court, okay. Ms. Irvine, but I do not. The court, well, I'm going to allow it to be late filed now. If you all need to argue about it, Ms. Irvine, yes. The court, let me know and we'll, Ms. Hall, well, I'm curious to see what the total is. The court, we'll schedule a time for it. And then to be fair, Ms. Hall says, before I give closing argument, which she then went on to give anyway. And then they go on discussing other things. The point of me reading that specifically to you today was to point out that the court made it clear to counsel that if there was going to be an objection to the attorney's fees, the court would schedule a time to have a hearing on those attorney's fees. But counsel did not, again, file any type of motion objecting to the attorney's fees after the exhibit was filed. Therefore, it's our position that they have waived that attorney fee claim. Now, I want to address a couple other things about the attorney fee claim, because that's obviously the most substantial claim in this case. I mean, frankly, the $12,000 alimony in Salido, while we believe that award is fully justified, it's kind of small potatoes in the full realm of this case. It's only transitional alimony. It's only $1,000 a month for 12 months. We think it was well within the trial court's discretion. I believe our brief bears that out. But on the $75,000 attorney fee award, the trial court was in a unique position to be able to observe the litigation that happened in this case and to determine, well, I think one party litigated more excessively than the other. And in particular, that there was one series of filings that were uncalled for. And that is, I would say essentially, but it's actually explicitly what the trial court did in this case. I mean, the trial court looked at the petition for criminal contempt, which was over $13,000 in allegedly dissipated or their allegations was it was contemptually disposed of property. And the court said, litigating to this extent over this small amount of property was unreasonable. And the trial court is entitled to make that determination. Now, opposing counsel, in their reply brief, I don't believe it was actually fully addressed in their initial brief, but in their reply brief, they bring up a whole bunch of pleadings and allegations and et cetera that my client allegedly made that their position were unwarranted. But the trial court is allowed to determine in its determination of attorney's fees, well, these, I heard this case, I found that these pleadings were warranted and these other pleadings were unwarranted. And so with that being said, again, the trial court did not award the full amount of attorney's fees to my client. My client had a $200,000 attorney fee bill. The trial court only awarded $75,000 for attorney's fees, which was the trial court's determination of what was an appropriate attorney fee alimony in Salido award to give in this case. I'd like to talk about the itemization of fees because I think that's kind of it's obviously a difficult spot or difficult aspect of this case for my client. The fact that there was no specific, we spent this amount of time on this thing, this amount of time on the other thing. I will say it wasn't just the affidavit that was filed, and you can see this in the record. The affidavit that was filed was not just, I want to be clear about one thing. The affidavit that was filed, it's actually in the technical record because it was filed with the clerk's office. So I believe it's either Exhibit 47 or 48 in the trial Exhibit 47 or Exhibit 48, but the affidavit of fees is filed. It can be found in the technical record. In any event, that affidavit of fees is not just, we spent $200,000 on this case, give it all to us. The affidavit of fees does specify the attorneys and/or legal support staff that worked on the case, specifies how many hours they spent, and specifies the charges for those respective hours. It does not detail a line, item by item amount, but we submit that that's not necessary in this case. The trial court was entitled to, again, look at the totality of the case, look at the pleadings that had been filed, and say, we think the $75,000 is a fair amount to award wife based upon these pleadings, which were, unmerited in the context of the litigation. So, that's our position on that. With regard to the transitional alimony, I would rest on our brief on that point. The wife showed a demonstrated need. Husband had an ability to pay. It's a modest amount of alimony, and we think the alimony is warranted. I want to also bring up, because trial counsel mentioned it, I also want to bring up the standard of review. And I don't want to sound like I'm whining. I don't want to be one of these attorneys that gets up here and says, well, they didn't do this or they didn't do that. But we have rules of appellate procedure for a reason. They, in their initial brief, did not set forth fully, to be candid, the proper standard review. They did set forth a partial standard review, but they didn't set forth the standard review which kind of applies to the very issues they're appealing. And then in their argument section, the way in which they approached trying to overturn the trial court's decision was basically asking this court to reweigh the factors or reweigh the evidence and, come out the other way, instead of taking the abuse of discretion standard and explaining why specifically the facts of this case and the trial court's ruling match the abuse of discretion standard. So I pointed that out in my brief, that they had failed to do this, and then I went forth and said, why it's not an abuse of discretion. And then when they came back in their reply brief, they then did try to say, okay, well, these are the facts that support the trial court finding there to be an abuse of discretion. But as this court held in the Levy v. Franks case, and that's Levy v. Franks 2, the one that came out, I believe it was 2024, maybe 2025. In the Levy v. Franks case, it's fundamentally unfair to ask the appellee to respond to something that for the first time is brought up in the reply brief. And all of their application of the standard of review to what happened in this case really begins in the reply brief. And for those reasons, we would argue that, I didn't go through line by line of their reply brief and say, this argument raised for the first time, this argument raised for the first time, this argument raised for the first time, because frankly, so many of their arguments in their reply brief were raised for the first time. But we would argue that those arguments are waived. They're not really entitled to any relief on this case because they haven't taken the standard review, which is abuse of discretion, applied it to the court's ruling, and explained to this court why the trial court's ruling abused its discretion. And so that is all I have with respect to this case. Respectfully ask the court to affirm the decision. Oh, wait. I misspoke. Apologies. There's the issue of attorney's fees. I forgot about that. So they asked for attorney's fees, appellate attorney's fees in their brief. It was very short, kind of cursory argument for appellate attorney fees. As I point out in my brief, they've waived that issue because they've failed to develop an argument on it. In our brief, we point out why wife should be entitled to her attorney's fees on this case. Her appellate attorney's fees in this case. And I want to make the point very clearly that you have this ruling decision by the trial court, which was not an abuse of discretion, and which provided wife with two different types of alimony. And then that was appealed by the husband. Wife made no appeal. So all that she's doing is trying to uphold the trial court's order to get the alimony which she is entitled to under the law. And given the facts of this case, we don't believe that it is equitable to require her to pay additional attorney's fees because husband decided to file an appeal contesting an alimony award to which she was entitled. So basically, we don't think it's fair for her to have to pay her attorney's fees just to uphold an award of alimony to which she was entitled. With that, I have nothing further left to offer on this matter, and I respectfully ask the court to affirm the ruling of the trial court in all respects. Thank you.
Thank you. We'll hear from the appellant in rebuttal.
Thank you. With regard to the passing reference that the trial court made to 36-5-121, I don't think that was sufficient. And even if Your Honors think that it is sufficient, the court still did not do an analysis under 36-5-121H, which is a separate section that addresses criteria that must be addressed when attorney fees are awarded, or under Rule 1.5. So there are numerous issues with the trial court's findings of fact and conclusions of law as it relates to attorney fees. As it relates to this issue about whether it's waived because there wasn't a request for a hearing, I would submit that what counsel did reference, that exchange that took place, I had made it clear that I wanted to have a copy of the affidavit prior to closing argument, and that didn't happen, and the court wanted us to go ahead and do closing arguments that day. And I would submit that if Your Honors review my closing argument, I absolutely objected as to the reasonableness for $200,000 of attorney fees for this short-term marriage. $200,000 well exceeded the entire marital estate. And I made that argument in my closing argument without having the benefit of the affidavit of attorney fees, which even if I'd had the affidavit of attorney fees, I wouldn't have had the billing statements or the contract.
So you're saying that at the time of closing, you knew the total only?
I knew the total only, and there was I knew the total only, that's correct. There had been some prior affidavits filed earlier that had a summary of what work was done, but no billing statements had ever been provided, and I did not know what the current balance was of the attorney fees. I knew from having received prior affidavits that were submitted prior to trial or at the beginning of trial that the fees were excessive. And so I made that argument based on what I had known the fees to be before the trial began. But at the end of a 5-day trial, of course, the fees are going to be a whole lot higher than they would be at the start of that trial.
So you didn't see the full document then until after closing arguments had concluded and court had adjourned?
That's correct.
All right.
As it relates to this petition for criminal contempt, I want to be clear that the wife herself admitted to giving away or selling this personal property. So it's not as if this was a meritless petition. This was strictly a strategy decision based upon the fact that the wife had hired a criminal defense attorney to separately handle that petition for criminal contempt over personal property. And that attorney was not available on our trial date, and my client wanted his day in court and just wanted to get this over with. And so at that point, coming right up to trial, we dismissed that petition for contempt so that it wouldn't be an issue and so that we could go ahead and proceed to trial. But the trial court herself, in her findings of fact and conclusions of law, acknowledges indirectly by saying that the wife dissipated marital property, that the wife committed the acts that were alleged in the petition. And regardless, that petition for criminal contempt would not have resulted in an award of $75,000 in attorney fees, which exceeded the entire amount that my office billed on the case. So the trial court erroneously cited to that in making her finding. It really has nothing to do with the alimony factors. The court herself doesn't really discuss it when it comes to the fault ground over the 3 pages where the court goes into fault. So it really doesn't have anything to do with the award of fees under the law. So again, I would submit that the trial court erred in awarding the attorney fees. This was not an appropriate case. There was not a need for the payment of fees. Wife's fees had been paid by her parents. The trial court herself, in the debt section, when she's going through what the parties' debts are, did not address the wife owed her parents' fees. It wasn't even listed as a debt to be allocated to either party. And the wife didn't include it on her 14C or 14D. So the court erroneously awarded wife attorney fees, and we submit that this court should reverse both the alimony award and the attorney fee award. Thank you.
Thank you, Ms. Hall. Thank both parties for their arguments. We will take this matter under advisement and get you a written opinion as soon as possible. Madam Clerk, would you adjourn us to the call of the next docket by the presiding judge?